Good afternoon, ladies and gentlemen, our online audience and our live audience on YouTube. Welcome to today's webinar by the Chartered Institute of Arbitrators, the Ugandan chapter, where we shall be getting into the ins and outs of enforcement of foreign arbitral awards. We will be starting shortly. We'll give it about a minute and a half for the queue in the participants trying to log on to get on, and then we'll start right away. Welcome to today's webinar, and I hope you will be informed and you'll be educated and you'll have something to carry away from this time that you'll spend with us. Thank you very much for joining us. My name is Mariam Nansambaiga, a member of the Chartered Institute of Arbitrators Uganda, an arbitrator, a member of the Chartered Institute of Arbitrators UK, and ICAMEC and the ADR family. I will be introducing our guests, our panelists shortly, and we'll just go through a few admin things. If you have any questions or comments, kindly feel free to use the platform, either by way of raising a hand or by texting, typing out a question in the chat that we shall respond to at the time we shall indicate to you during the time we'll spend on this webinar. Kindly mute your microphone so that we have minimum to none interference so that we can maximize the time we'll spend on this webinar. And feel free to take time after this webinar to check out what else Chartered Institute of Arbitrators is all about on our socials, so that you can keep up to speed with our calendar. We have a lot of professional activities going on till the end of the year. So once again, welcome. Today's webinar is about enforcement of foreign arbitral awards. And to be able to discuss and analyze and appreciate the importance of these foreign arbitral awards in the ADR space, we have a panel of experts, industry experts, leading experts, not just lawyers, but practitioners across the financial, economic, and business spectrum that are going to break down for us in the simplest terms, but also in depth, about what foreign arbitral awards are, but also take us through the nuances and the landscape for enforcement. We all know that there's cross-border transactions that are increasing, and therefore there's a complexity of dispute, there's a complexity of interests and priorities, and the ability to resolve an international dispute plays directly into the investment favorability of a nation, a state, or an economic trade area. So without further ado, allow me to introduce our panelists for today. In no particular order, we have Mr. Chirunda Robert. Robert is an accomplished advocate and really needs no introduction. But for those who are hearing about Mr. Chirunda for the first time, he is an experienced legal practitioner with both breadth and depth. He's an impeccable lawyer and has an excellent record in litigation, handling high-value and strategic disputes. Robert's specialized knowledge is in modern financial markets, tax practice, emerging technologies. He advises several clients on complex multi-sectoral transactions while offering a pragmatic and commercially focused and astute perspective. He has advised and participated on many national policies, and he's part of general law and reform for many. Say about Robert, and I believe by the time we get into this discussion, you'll get to understand why he was the choice person to be on this discussion for today. Next is David Kagwa. David Kagwa is also an accomplished lawyer and arbitrator. He is a member of the Chartered Institute of Arbitrators, to say the least. He is a member and a director at the Construction Law Institute. He's a fellow, not just a member of the Chartered Institute of Arbitrators. He's a member of the Construction and Law Society UK. He's also a member of the London Court of International Arbitration in London, and so many spheres where he's wearing hats both as an arbitrator, a renowned arbitrator, but also a construction law expert. And third on the panel, the accomplished lawyer and practitioner of ADR. He's a member of the Chartered Institute of Arbitrators, a fellow at the Chartered Institute of Arbitrators. He's also a director at the African Center for Effective Dispute Resolution, which is a non-profit organization, and is also a founder of a leading law firm in this country. Their bios and their professional accolades go beyond time, what time would allow us to delve in today. But I would like us to take this opportunity to hear from them directly, to share their knowledge, and to give us a good understanding and breakdown of what this foreign arbitral award enforcement landscape looks like. I welcome you again to this webinar, and I hope that you will stay with us till the very end for this jam-packed, insightful, educational session. Thank you very much. I'll give my panelists a minute to say hello to the audience, and then we'll start. We'll start with Robert.
Hi, good afternoon to you, Nanza. Thank you very much for such a humbling introduction. And good afternoon to all our colleagues and the people who have joined us this afternoon. Thank you for sparing your time. It's a privilege to be here. I'm grateful to the organizers for the invitation. Thank you.
Thank you, Robert. Albert, please say hello to the audience, then we get into the business of the day.
Thank you, Nanza, for this opportunity. I welcome all our participants who have taken off time this afternoon to join us. I hope this will be a fruitful discussion and be able to have a lot of engagement from the participants. Thank you.
Thank you, Albert. David, please.
Thank you, Nansa and Mariam, for moderating, and to our participants. Thank you for tuning in. And to our co-presenters, thank you for the work you've put in to prepare, and look forward to a fruitful afternoon of deliberations. Over to you, Mariam.
Thank you very much, David. We're going to start slow and easy as we get into this Foreign Arbitral Awards understanding. We'll go straight to you, Robert. Please break down in simple terms what an arbitral award is, what a domestic award is, and what a foreign arbitral award is, so that we can be clear from the onset what we are going to be discussing this afternoon.
Okay, thank you very much. So the basics, as I understand them, you have two parties to a dispute who have long decided how they want to resolve their controversy should it arise. At the point of entering the contract, much earlier before the dispute arose, the parties decided that should we ever disagree, then we are going to refer our dispute to a third party, a neutral third party, in this case an arbitrator. That arbitrator is going to be located somewhere. The decision of that independent third party is what we would call, from the arbitration process, is what we call the arbitral award. It is domestic in nature if the proceedings are conducted in Uganda under Ugandan law. It is foreign in nature if it is coming from a country where the law of the arbitration itself was the law of the country that is not Uganda, but is either a contracting state under the New York Convention or is a contracting state under the ICSID Convention. What that really means is, and here I'm relying on three provisions. Section 39 of the Arbitration Act defines a New York Convention award as an award that's issued from a contracting state under the New York Convention on the recognition and enforcement of arbitral awards. That convention, last time I checked, had over 160 members, so it's really most of the known world. The ICSID Convention, on the other hand, which is provided for under Section 45 of the Arbitration and Conciliation Act, is one of the agreements under which you have the institutions that we know as the World Bank Group, because there's 5 of them, and one of them is the International Center for the Settlement of Investment Disputes, which basically handles disputes between contracting states and private sector within the World Bank membership. So the Act recognizes those two specific frameworks, but you would find that they basically cover every country out there. So what happens is the arbitration need not be sitting in that particular location, but the law the parties agreed they would sit the arbitration under. If that law is from is the law of a country, let's say South Africa, the UK, Germany, any of those countries, if you say we will determine our dispute in China, because one of your parties is Chinese and China is a member of the New York Convention, then that's a foreign award. When you come to enforce it in Uganda, you would have to comply with the provisions that govern foreign arbitral awards, and that's from Section 39 onwards. I think I'll leave it at that for now. Over to you, Mariam.
Thank you very much, Robert. And that was a good and broad introduction of what an award is, an arbitral award is, what a domestic award is, and what an foreign award is. From your discussion, clearly, once an arbitral award is outside the country, it becomes foreign, and then other players come to play. You've talked about the New York Convention and ICSID, which we are going to get into shortly, and we appreciate that. And the next question will be for Albert. Now that you've introduced new stakeholders or legal players in enforcement of an award, an arbitral award that is foreign, that means it's important for our audience to understand the landscape. So Albert, if you may, would you please take us through the legal and regulatory landscape for a foreign arbitral award to be enforced? Thank you, Albert.
Thank you, Nanza. As Robert has pointed out, once we have a New York Convention award as provided for, or an ICSID award as provided for under the Arbitration and Conciliation Act, of course, the next step is how do you recoup the fruits of the award? And there is a legitimate and reasonable expectation on the part of the successful party that the losing party will comply or perform the award with the reasonable haste. And in most cases, this does not happen. So that's where the New York Convention comes into play. And fortunate for Uganda, the New York Convention has been domesticated. In other words, it's part of our law. So when you look at Section 42 of the Arbitration and Conciliation Act, it provides for how the award, the foreign award, will be recognized and subsequently enforced. Now, Section 42, unfortunately, does not go in detail. It just sends you to Section 35. And Section 35 is what provides for the formal requirements for enforcement. First and foremost, the original award as issued by the arbitrator, 2 certified copies of the same, and then copies of all original or certified of the arbitration clause. But most importantly, before you look at these requirements, as Justice Mubiru pointed out in both the case of Zabo and the case of Aya Investment, Section 31, which deals with awards generally, the form and nature of the awards, that is, they must be in writing, it must be signed by the tribunal, dated, and must be reasoned. Should also be complied with, especially in light of the award itself. So if a person or a party representative, like any of our participants, is charged with enforcement of an award, one of the requirements is, do you comply with Section 31? Is the award in writing? Is it reasoned? Is it dated and signed by the arbitrators? So once you finish those requirements, then you go to Section 35, and then you're able to follow what the provisions as I've highlighted. Then subsequently, you'll be able to apply to court. In the cases, of course, the procedure has been by way of chamber summons, and you apply to court for enforcement. So that is the process under which you'll be able to apply for recognition and enforcement. Thank you, Nanza.
Thank you, Albert. And for those of the participants joining us right now, welcome to this webinar by the Chartered Institute of Arbitrators, the Ugandan chapter, where we are breaking down the nuances around enforcement of foreign arbitral awards. We have a panel of experts that is breaking it down for us from first principles. We've come from basic principles of what an award is, a domestic award, a foreign arbitral award. Albert has taken us through the landscape and regulatory framework of enforcement. And as we all know, that enforcement is the most important part of any arbitral award. And if it's not going to be effectively and legally binding, then the parties have wasted time and resources in trying to resolve that dispute. So to take us further along on this enforcement journey, I'm going to request David to help us distinguish, again, from first principles, what is enforcement, what is recognition? Now that we know what an award is, domestic, foreign, David, please take the audience through on what the difference is between enforcement and recognition of awards, and where applicable in foreign arbitral awards. Thank you, David.
Thank you very much, Mariam. The distinction between recognition and enforcement is that, on the one hand, recognition is a defensive mechanism by a party to an arbitral award to have it recognized by a court in a country, with the effect that it creates a res judicata. Differently, once you have this award registered in Uganda, for example, it puts an end to any other litigation that may take place between the parties in respect of the disputes that was already adjudicated upon. So that's the first step to enforcement. It is declaratory in nature, but it has that strong effect that the court has confirmed finality of the dispute. Therefore, there cannot be parallel proceedings in respect to the same matter. Now, on the other hand, the aspect of enforcement is more to do with execution. The court can make the declaration that the award is recognized and enforced, but the process of enforcement is basically to use the state actors that the court process uses to convert that award into money. And the catchword there is Section 36 of the Arbitration and Concession Act, which provides that where an application to set aside an award has been dismissed, or the time for applying to set aside has run out, then that award shall be enforced as a decree of the court. So basically, enforcement is more of the execution part. Recognition is more of the protective mechanism in order to create res judicata such that that award is recognized in that country. Over to you, Mario.
Thank you very much, David, for breaking that down in explicit terms. And would like to pick up the next part of this discussion from your remarks on the finality of an award, an arbitral award, and a foreign arbitral award in this case. And because we've come down from basic principles up to this point, I would like to inform our audience that we were going to start a bit of depth by bringing into focus or highlighting on certain cases that have been handled before for foreign arbitral awards, some regional, some national, some international, so that we get a clear picture of what enforcement and recognition of awards is. But to pick up from David's last comment about finality and execution, I would like to request the panelists to take a minute or two, each in their respect, because an award being final, then we are speaking about foreign, where we have countries and sovereignty of states, could mean one thing in a country and another. So is every award that has been recognized enforceable? Is it mandatory to enforce it? I would kindly request the panelists to discuss this in light of public policy so that the audience is very clear on where the nuances now of international law and diplomacy and all that comes into play. So is every award that has been recognized enforceable? We'll start with Robert.
So that's an excellent question, Mariam. Thank you. Once you pass the setting aside and recognition test, then the award becomes a judgment of the court. And at that point, it is enforceable. Now, why I say that is because the only fetters, especially with international arbitration, there are only two fetters. Either you're saying the country from which the award came has set it aside, or you're saying the High Court of Uganda has found a reason to refuse recognition. The moment the court says the award is recognized, the award is enforceable, it is the duty of the court. In fact, the New York Convention requires the Ugandan courts to enforce that award and to, number one, to enforce, number two, to not put any unreasonable requirements in the way of enforcement. The idea is to enforce party autonomy. A really good way to understand this is to read the Court of Appeal decision in Babcon. I think that Justice Egonda's decision in Babcon was very instructive because he broke down the policy objective behind the amendment to the Arbitration Act and giving us the law as we have it today, which was to give life to efficiency and speed in resolving commercial disputes. You do not have an automatic right of appeal unless the parties agreed to appeal against an award. You have no right of appeal. Section 9 and Section 16 of the Arbitration Act make that very clear. The courts have really settled the question on to what extent will they intervene. Post-award, if there was no express right of appeal, you have no right of appeal. the creditor is at liberty to enforce that award with the full weight of a decree of the High Court of Uganda. That's perhaps would be the extent of my intervention at this stage, unless you'd like me to go any further.
Thank you very much, Robert. You seem to convey the spirit of arbitration very well, where parties have decided beforehand that they want to see this dispute not just resolved, but with a legally binding decision that is enforceable. And now that we are talking foreign arbitral awards, even the courts of the different states have been pulled along in the same spirit to appreciate the finality of arbitral decisions. I would like Albert to take us through the exceptions, especially in light of public policy. Is every award mandatory and must it be enforced? Albert, what are the exclusions? What does the law say? Do you have any cases that come to mind? Thank you.
Yes, as pointed out by David and Robert, there are two things, the two concepts of recognition, then enforcement. At the point of recognition, that's where we have grounds where the court may enforce. We have grounds where the court might refuse recognition. Accept recognition or refuse recognition. When you look at these grounds, they are similar to what is provided for under Section 34, grounds for setting aside. However, as Justice Mubiru in the two cases of IR investment and the latest one of Zabo and Great Lakes, he points out that the effect is different when it comes to the two sets of grounds under Section 34 and then the ones for refusal for recognition. That's the effect that, whereas in Section 34, it would have the effect of annulling or setting aside the award, under refusal under Article 5 of the New York Convention, the grounds would have the effect of the court refusing recognition, and that would also mean there would be no enforcement. So, in other words, you cannot have enforcement without recognition. So it is important that this is understood, that for you to have enforcement for a foreign award, you need it to be recognized. And as David pointed out, it's a defensive mechanism. If it is enforced, if it is recognized, then you will enforce. If it is not recognized, then that's where it ends. So I think these cases, Nanza will provide them in the chat for the participants to be able to look at the procedure. And if the procedure is not complied with, as Justice Musota pointed out in the case of Sterling versus the United Republic of Tanzania, then the court will not entertain the application. So it is important. Then when it comes to public policy, if I may put it, public policy is one of the grounds for refusal for recognition.
We seem to have lost Albert. Oh, he's back on. All right. Go ahead, Albert.
Yes. Yes. What I was pointing out, when you look at the two judgments of IR investment and Zabo, the highlight of what the judge tries to point out, that there are two ambits of public policy: international and then domestic. And it is more favorable to look at the international perspective of public policy, because these are principles that cut across the world, which are acceptable to every, what he points out as civilized world, compared to domestic. Because in the domestic setting, a country might refuse recognition on account of public policy, which is only unique to that particular country. So it becomes problematic in terms of recognition of an award if we restrict to the domestic policy consideration. But then he goes and says sometimes it is easier to have an amalgamation of both the international and the domestic ambits of public policy for purposes of the court making a decision, because public policy is incapable of being defined. What is acceptable today may not be acceptable by the time the proceedings are concluded, may not be acceptable in the following year. So it is important that the parties or even the arbitrators, while deciding these in the proceedings, to be able to have these public policy consideration at the back of their mind, but most importantly, for them to be definitive at the time of their recognition of their award and subsequent enforcement. Thank you.
Thank you, Albert, for that elaborate explanation on one, the importance of recognition, and therefore it being a defense mechanism for enforcement, and then taking us through specifically to the legal limitations where enforcement may not happen because of the legal limitations that you've mentioned. Those who are joining us, welcome to today's webinar organized by the Chartered Institute of Arbitrators, the Ugandan chapter. We are discussing enforcement of foreign arbitral awards, and we have a panel of experts taking us through bit by bit, baby steps, hand-holding us as we move into the deep end of this subject matter. Again, if you have any questions, comments, anything to add to this body of knowledge, please feel free to use the platform. Send a text, send a comment. Somebody on the admin side is going to share the cases, because now we are getting into the deep waters of the course of the content, and we will need to refer to these cases from time to time. But before we get into that, I also want to let you know that our panelists are not just serious lawyers and highly accomplished, no-nonsense people. They are very good storytellers. And just to bring the last point home about public policy and refusal to enforce, I know Robert is very good at telling stories. Robert, have you come across any cases where, after all has been said and done to recognize an award has not been enforced purely on public policy grounds? I think the audience would be curious to know.
Nanza, if you get me telling stories, we might spend the whole afternoon. So I'm going to try and stay away from that temptation. The question of public policy has been a fairly elusive one. I'm trying to recall which decision it was. I do know that it has been, there was a Kinyara decision that was set aside, and David might remember the parties better than me. Our senior colleague, James Nangwala, argued that matter. For some weird reason, the name has completely escaped my mind. The full citation has escaped my mind. But it's, as wide as that unruly horse of public policy, as Lord Denning once called it, is, it's actually not very easy to succeed on that. It came up in Zabo. The question of corruption came up in Zabo as a basis of public policy, although the latest Zabo ruling, also Zabo has a number of rulings. I don't know if our colleague, Mr. Mafari, is on the call. He would point us to exactly which one, but there was the consideration, and the parties argued forcefully around the question of whether or not a party giving a bribe or essentially, not to the arbitrator though, procuring a project by corruption amounts to a breach of public policy. Justice Mubiru seems to have stayed away from the question entirely, and he has ordered enforcement of that particular arbitral award. So anyone on public policy that has forcefully fleshed out and set aside an award, other than Kinyara, which was many years ago. These days we separate the world in terms of pre and post-COVID. This was long before COVID, which I think is why my memory is foggy. I cannot in the last few years very quickly point to one, but I'm curious if my colleagues have one that comes to mind.
Thank you, Robert. David, any case that comes to mind where we can move away from Uganda and try the continent or the region?
Oh, yes, Nanza. In last year, 2023, the High Court in the United Kingdom refused recognition of an award in the case of the Republic of Nigeria versus Process and Industrial Developments Limited. It's a very interesting case because the court did not find any misconduct on the part of the arbitrators. A very interesting case. The arbitrators were blameless, but nevertheless, the courts refused recognition of an award on the basis that it was procured through corruption. Not the award, but the contract under which the arbitration clause was enshrined was allegedly procured through corruption and bribery. And there were also serious findings by the judge that some of the lawyers for the state were being paid by Process and Industrial and thereby compromising the case of the state. It's one of those unique cases where the court goes outside their ambit to look at things which ordinarily are not expressly stated in Article 5 of the New York Convention. So, but the explanation may be that the of the UK has set aside an award, such a wide term that most likely the judge in Nigeria versus Process and Industry may have used that latitude to go to great length to basically refuse recognition. So that's one of the things I can look at. And then another thing was, of course, one of the Zabo cases where the judge refused to recognize a certain award, which according to him was contrary to public policy. He believed that certain remedies which had been given by the award, by the arbitrators, were confined to the Electricity Disputes Tribunal, and that the arbitrators did not have the jurisdiction to decide that aspect. And then there is also a decision still by Justice Muiru, which involved Uganda Government Corporation versus Rock Trust Contractors, where the judge refused to recognize part of the award, which according to him was contrary to public policy, because the award included an amount granted under the principle of quantum merit. According to the judge, it exceeded the threshold that the PPDA regulations would allow. So those are the few cases that I can remember. Over to you, Mariam.
Thank you very much, David. That was those were insightful cases. And just to wrap up this point, because this is where interests lie, national and other, I'd like Albert to give us a quick one for the listeners and participants out there who are wondering, from the case of Nigeria versus PID, as you elaborated. There was an issue with the contract and the arbitration process, where the arbitration process was not flawed, but issues were found with the contract leading to the arbitration. Albert, would you please shed more light on the separability of the arbitration clause and the arbitration contract, just to help our participants get the principles of arbitration deeply ingrained? If we can use the same case, or generally an arbitration clause, how it's separate from an arbitration, from the contract itself. Thank you, Albert.
Yes, thank you, Mariam. Of course, what is important, one of the cornerstones of arbitration is that the clause or agreement to arbitrate is separate from the substantive contract which the parties have entered. And it is important that if there is anything that would render the substantive contract unenforceable, then it does not affect the arbitration clause. So that is where the doctrine or the principle of separability or severability comes into play, because if the substantive contract is found to be null, void, and unenforceable, then the arbitration clause is severed from that substantive contract. And it is, the whole idea is to preserve the parties' right to determine their disputes by way of arbitration. So the parties should not be left without a remedy. And this goes to the core of the equitable principles. No party will be left without a remedy. So it is applicable, like the case David pointed out. The courts will go to the extent to see what is the underlying relationship between the parties, and then attempt to see whether there will be grounds on which the courts might set aside, and that is one of them. And I think there's another one of Dubai duty-free in Kenya. Equally, it was set aside on the grounds of corruption. The claimant had paid the officials or Kenyan officials. So it is, I think it is a wide concept, but it is to be looked at more closely, especially in light of the principle that you have highlighted. Thank you, Mariam.
Thank you very much, Albert. And time is catching up with us very fast. We are quickly going to move on to the next segment. And I'm going to ask Robert to take us through, based on the Aya versus IDC case. Because Robert has specialized knowledge in financial markets, tax, and all those emerging technologies and contemporary issues, one is going to give us a brief summary of the case to help us appreciate the nuances when it comes to enforcement, things to do with collateral, cross-border transactions. So, Robert, if you may, please take us through, in general terms, you're the storyteller for the day, what the Aya case is all about, and what stood out for you in general terms. Thank you.
So Aya was a convoluted dispute, and I use the term convoluted because A, it lasted much longer than any reasonable dispute should last, but B, it involved many twists and turns. The final decision is a simple 39 pages, 10 of which are recounting facts and arguments. And so Aya versus IDC is really the financing of what we know as the Hilton Hotel in Nakasero. Was supposed to be the Hilton. I think it now has a different name. Gosh, today my memory is just off. But Pearl of Africa, that's the name, yes. Pearl of Africa. You have a series of contracts that are brought together to really, which is not uncommon. The lender is advancing funds and tranches, and you have drawdowns in the financing structure. And then you have 6 financial credit agreements that comprise the lending package. But the lending package also has a security package attached to it. And the security package will essentially, that's where you have your mortgages. In some cases, you'll have your charges and whatnot. It is common in these kinds of transactions to have documents that are a series, and if the lawyers are not watching the clauses carefully, you will have certain clauses on one end and other clauses on another. The issue that I think was one of the things I found interesting was that you had a set of financing agreements, credit agreements that required the parties in the event of a dispute to go to arbitration. And then you had mortgages that did not specifically provide for arbitration. Now, a dispute has arisen. Justice Mobiru says you have to first establish what is a dispute. Is there a dispute, in fact? That's actually a requirement of the Arbitration and Conciliation Act, because for you to refer a matter to arbitration, you must know that there is, in fact, a dispute in terms of Section 3 of the Act. Once he does that determination, he then goes on to say, okay, what kinds of disputes are arbitrable? And that's when he touches on what disputes are not arbitrable, the issues of sovereignty that you talked about. For example, you can't arbitrate criminal matters, you can't arbitrate matters that are the preserve of the state, which the law specifically divests to tribunals. And I think David touched on that point as well. And on sovereignty, and then there are those functions that are the preserve of the state. I would use the example here of taxes. We saw this in the tax cases back in 2014, which went to London and then came back to TAT and then the High Court and so on and so forth. But then he gets to the point, and the one I want to highlight is the question you touched on with regard to securities. What happens where, on the one hand, you have a financing document that talks about arbitration, and you have a collateral contract, a mortgage, that does not talk about arbitration. The principle, as he sets it down, is that there must be something in the collateral contract that shows and demonstrates an express or conscious agreement that arbitration was the ultimate dispute resolution process. So you have to be able to tie the two. Of course, the smart and wise thing to do is to make sure that your security documents mirror the dispute settlement mechanism in the primary contract. Now, I've seen many colleagues and people from firms that have handled these large transactions. Two things will usually happen. One, parties have negotiated for so long from the term sheet all the way to the financing that they're exhausted. Two, you may actually have a mismatch of counsel, and one of the counsel is not sort of switched on enough to detect that there's a mismatch. Three, you could actually have people switch. I was once involved in a transaction where they brought me in after parties had negotiated 8 months. And at that point, everyone is just wary. They're suffering deal fatigue. So for you to go back and reopen things they've negotiated, you sound like an annoying person. But that's how you end up. There's any number of reasons how you end up with agreements that are not matching across. Now, Justice Mubiru then goes ahead and says, parties may incorporate, you may incorporate the reference to arbitration either generally or specifically. The preferred approach is to be specific about it. Now, where one of the parties did not have notice of this intention to incorporate, then the incorporation must be expressed. However, he then deals with, he takes it further. I think the way he dealt with that point was actually quite interesting for me. He goes further and says the parties must ordinarily arbitrate what is arbitrable and litigate what is not arbitrable. So he starts by saying you can actually bifurcate the proceedings. Take to litigation what is not arbitrable, arbitrate what is. Then he goes on to say, wait a minute, that process has a downside. There are two things. The first thing is where the security interests or the collateral interests are so inextricably interwoven with the main agreement that has arbitration, then you must arbitrate the dispute. It fosters judicial economy. Also, it will not be possible to resolve one without resolving the other. In that context, go ahead and arbitrate. But where you can actually sever the two and resolve the dispute without the two mixing, then the preferred approach is stay the litigation, handle the arbitration, come back to the litigation. What I think would be the practical thing, especially in a financial lending, is that you will end up resolving these issues in arbitration, but the point must be canvassed. And if I was sitting as an arbitrator, I would make sure that I would require the parties to address me very specifically on whether or not this particular issue is arbitrable. Is it inextricably interwoven? Can you resolve one without the other? Because that would also go to the point of jurisdiction of the arbitrator to reach that finding. Because in Aya, the question did come up as to whether the mortgages were within the remit of the arbitration. And Justice Mubiru makes a finding where he says those mortgages in and of themselves were actually not within the remit of the arbitration. But then I believe he does go ahead and order enforcement because of the inextricably interwoven nature, him having found earlier that the contract was in fact, the lending dispute itself was in fact arbitrable. Why don't I leave it at that for my colleagues to chip in?
Thank you very much. That
Because
was
is very loaded.
yes, it is.
And I think I would rather leave some of these points for David. Is a much better storyteller than me, by the way.
We are coming to his stories. Don't worry. His turn is coming. But thank you so much. You've taken us down a rabbit hole in this whole financial credit agreements, collateral security. You've brought in issues of arbitral jurisdiction, interwovenness. Basically, the lines are very, very close when it comes to such disputes. Maybe for us to wrap up, point up well, we would like to get to hear your thoughts. If the collateral under security, Robert, to you again, is such that it is leaning towards compromising, again, the issue of public policy, what are the remedies for the parties now? Because you say we litigate, stay the litigation, arbitrate, and come back to litigate. If we go do phase one, stay it, go to phase two, we arbitrate what's arbitrable, and then we come back to litigate what should be litigated. And then at the point of enforcement, because this whole foreign arbitral award thing only makes sense if it's binding and there's enforcement to some degree. So when we go to the securities and the collateral, if people are going to lose jobs or livelihood or compromise community safety or the issues around public policy, what are the remedies then if the collateral can't be touched?
So, sorry, I was talking to myself just a minute. Now, two things there, Nanza. The first is, think about arbitration in the context of both the court and the arbitrator are going to be looking towards how do you give purposive effect to the proceedings before you within the remit of the law. I believe that what Justice Mubiru is saying in Aya is that take an approach that gives you as much as possible the intention of the parties. Now, you're going back in time to say at what were these parties thinking at the point of contracting, not at the point of the dispute. So let's start with the fact that if you mortgage property, the Ugandan courts have said you should have a reasonable foreseeability of the fact that you could lose that property in a sale. Unfortunately, the wider questions of people losing jobs and securities being sold, that is the nature of the business. Those are the consequences of what happens when the chips must lie where they fall, number one. Number two, I believe what the arbitrator will do is to study the dispute and say, there will be, and Albert touched on this, there will be no wrong without a remedy. That's at least the policy that I've seen coming through the courts in the various recent decisions, all the way from Lakeside, which I think David may have handled or knows even better than me. The courts are saying, if the parties intended to arbitrate, let them arbitrate. Once arbitration starts, let it resolve every foreseeable question with finality. Now, the point about finality is, number one, the arbitrator will have to determine every point before them clearly and to render a decision so that you don't end up with vague questions on. I don't think it's a public policy question as to what would happen if certain things are done in accordance with the law, such as realizing security. That's, for me, not a public policy question. Public policy is something like, would this ideally be something we should consider illegal or immoral? There's nothing immoral about selling a building. There's really nothing immoral about collecting a debt. You borrow money, you pledge collateral, you fail to pay, we sell the security. once we finalize. Or you come and give us, you come and argue. Let's not discount the fact that a debtor has the right to protest the sale in the proceedings. So if you believe a security should not be sold, challenge, make your argument during the arbitration. Once a finding is made on whether or not that security should be realized upon, should be foreclosed upon, that finding will be binding. In fact, some of the arbitration houses, the ICC rules, for instance, contain a specific provision that says once an arbitrator reaches an award, both parties, by choosing that arbitration house, have in fact committed to abide by that award. So those are the interesting issues. Unfortunately, by the time you get to the award, so many of the questions people ask at that point should have been answered. David was in court recently. David, I have to steal this story from you. And he was handling a matter where the judge said to his colleague, said, you do realize that with arbitration, the moment you sign that agreement, you start closing doors. And that's just the nature of the process. And that also, going back to my point earlier on Babcon, is the policy objective behind arbitration. It should be faster than litigation. And in my experience, it has been, in the arbitrations I've handled, it has been much faster. In very complex disputes that would have taken at least 4 years. If you pick up any judgment, go to Yuli, just queue in any decision, you will see that the average time from filing to decision is 4 years. In arbitrations,
seem to have lost Robert. And
can you
you're
hear
back?
me?
Please go ahead. Please go ahead. Now we do.
Okay, I was just saying that, let me wrap up with this point. I was just saying that arbitration is meant to be fast. The most complex arbitrations I've seen have lasted, in one case, 1 year and maybe 4 months, in another case, about 9 months. Those two arbitrations were very high value, very contentious, and if they had gone through litigation, I guaranteed they would have spent at least 4 years between the POs and the applications and whatnot. So the only way you achieve that is by determining questions one at a time with finality. And that's really where I think the distinction must be drawn behind what seems painful versus what is against public policy. That's how I would put it, perhaps.
Thank you very much, Robert. You've given us a good breakdown of what remedies are available to a party where, as far as financial and credit agreements are concerned. And to wrap it up, sounds like a cautionary tale that while we get into this, first of all, series of financial agreements, we should always remember or be careful knowing how each speaks and ties into each other. And we appreciate that. For the audience that is texting and sending questions, we do see them, we do acknowledge them, we see your feedback. We will get back to you in another segment and respond to your questions and get your thoughts. But right now, we would like to turn to another storyteller that Robert has been co-storytelling with, that is David. And we are also going to shift gears to move into the region. We've had the Aya case for Uganda. We are going to find something within the region, and hopefully before this webinar ends, we will have taken an international flight in the enforcement circles. So David, in the matter of Sterling versus Republic of Tanzania, please give us the brief breakdown of what the facts are, and help us appreciate enforceability in light of a seat of arbitration, where we have a foreign award or an international arbitral award. Thank you very much, David.
Thank you, Maria. That case of Sterling, the decision of Justice Musota as then was, it was a procedure that counsel for the applicant had applied the wrong procedure. So it wasn't very useful regarding jurisprudence, apart from the judge emphasizing the fact that enforcement of judgments has a different legal regime from enforcement of arbitral awards. But the two cases which are rich in jurisprudence regarding enforcement and recognition are the two Zabo cases and the Aya case. Now, the Aya case, one of the questions that was before the court was whether or not the High Court in Uganda had jurisdiction to set aside that award. And the judge held that the fact that the seat of arbitration, which is the legal jurisdiction under which that arbitration was anchored, because that legal jurisdiction was in South Africa, the judge held that the courts in Uganda did not have jurisdiction to set aside the award. But the judge went ahead to pronounce himself on aspects of enforcement and recognition, and made findings that the award from South Africa complied with the requirements under Article 5 of the New York Convention on Enforcement of Foreign Arbitral Awards. So one key takeaway from this decision is that whereas setting aside is only restricted to the country that has been named as the seat of arbitration, enforcement can take place in any of the partner states to the New York Convention. So Uganda and South Africa are parties to the New York Convention. Therefore, the Aya award was enforced, but the court declined to deal with the setting aside application because Uganda was at the seat of arbitration. Now, another take home from the Zabo and the Aya case are two very distinct aspects. The first one is when trying to refuse recognition in the Zabo case, the applicants alleged that the arbitrator went beyond their jurisdiction. Basically, they handled issues which were not arbitral. They believed that these were insolvency matters and the High Court would only be the one to decide those aspects. Now, the court made a very important finding for practitioners that when court is construing arbitration clauses, it uses a wider interpretation. The judge referred to it as in favorem rule, in favor of. It uses a wider interpretation when looking at the arbitral clause that's giving jurisdiction to the arbitrator, in such a way that court will not refuse recognition just because an arbitrator decided certain aspects which were not arbitrable. So in essence, if the matters which are arbitrable and those that are not arbitrable are so interwoven together, the court should use a wider interpretation to construe that arbitration clause in support of arbitration. Therefore, the court will enforce the award. Now, the contrast to the wide interpretation is the second take home from the Zabo case. That when dealing with public policy, now the court must use a restrictive interpretation, a narrow interpretation. And the rationale is that the spirit behind the New York Convention was to support arbitration. That's the spirit behind it. Therefore, public policy, when applying it on whether or not court should enforce an award, the court will use a very limited scope. It will be restrictive. But when the court is looking at the jurisdiction of an arbitrator, it should use a wide interpretation. Over to you, Mario.
Thanks, David, for breaking down that seat of arbitration concept very well. And we appreciate that. But before you get off this point, David, you've been very articulate on where the role of finality and declaration is. That is a recognition. And at that point, the seat's job is done. So what would be the 2, 3, 4 top of your head guidelines or guiding principles for enforcement for a party that has now received an award and has the 169 countries as options to choose enforceability? What should they be looking at to have a successful enforcement?
Thank you, Mariam. First of all, My colleague Albert talked about the requirement of the law on enforcement. And I would say what is required for enforcement of foreign arbitral awards is similar to what's required in enforcing domestic awards. Basically, the checklist is one, that you have an original award or a certified copy thereof. Secondly, that you have the original contract, which has the arbitration clause, or a certified copy thereof. And then you must include a declaration that the award has not been complied with by the other party, or the extent to which it has not been complied with. The rationale for this is that courts must not be engaged in an academic exercise. If there is an award and you've been paid, there is no business why you need to bring it and have it registered and you close the court system. So basically, that's what I would say regarding the first steps that a party needs to enforce. But then secondly, it's a question of style, because if you're faced with a respondent who has assets in Dubai and he has assets in the United Kingdom, and you have an award made in Uganda, and you realize that a big part of this award is interest, you're better off, as a matter of practice, to choose a jurisdiction which has assets, but also whose public policy is in favor of the awards you've received. If you made an application for enforcement in Dubai and a big part of your award is interest, it's very likely that the courts there will not enforce that part of the award. And by the way, we should not confuse this. A court's refusal to enforce doesn't mean that the award has been set aside. It remains intact. It means you can take it to another country whose policy allows interest. So if you have a respondent whose assets are in Dubai and United Kingdom, you're better off going to the United Kingdom, because one, they are pro-arbitration, and secondly, it will be very easy for them to enforce an award of interest, unlike Dubai. So on top of complying with the checklist as I've stated it, you need to be very mindful of which jurisdiction you go to that has the assets, but also which is pro-arbitration. Over to you, Mario.
Thank you very much, David. You've highlighted a very important principle of being aware and moving in wisdom as you choose to enforce and execute an already recognized award. And that takes us right into the next level of this discussion. We are going international as promised. And to take us there is a third storyteller, that's Albert. Albert, the doctrine of comity focuses on maintaining amicable working relationships between nations. And for purposes of appreciating and understanding comity, we are going to refer to the SO, that is Shell Nigeria, versus NPPC, that is the UNOC of Nigeria. So can you take us through this case in light of comity, give us some background and all the good stuff regarding comity and international relations when it comes to enforcement of arbitral awards. Thank you, Albert. Over to you.
All right. Thank you, Nanza. This decision is SO Exploration and Production Nigeria Limited and others versus the Nigeria National Petroleum Corporation, as you have mentioned rightly, which would be equivalent to a UNOC. The decision was made in the United States, in the United States Court of Appeal for the Second Circuit of New York. So the decision, basically, without delving into the facts, basically there was an award against the NNPC, and the award was registered in the courts in Nigeria. Part of the award was set aside. However, a party decided to take the same award to the United States for purposes of enforcement. And the Second Circuit, which would be an appellate court, was of the view that in light of the fact that part of the award was set aside in Nigeria, it could not enforce the award in its entirety. And this was because looking at the fact that one, the United States and Nigeria, both New York Convention members, but most importantly, a distinction had to be drawn between what would be a primary jurisdiction, which would be the seat of arbitration, and the secondary jurisdiction, where a second country where a party wishes to enforce this award. And in line with Article 5(1)(e), one of the which specifies that an award may be refused recognition or enforcement if it is annulled by the court of the arbitral seat. So in light of the fact that the seat being Nigeria, part of the award had been annulled, the United States could not just enforce the entire award because they're both New York Convention members. It had to look at, one, respect the findings of the court of the seat, and secondly, also look at what the New York Convention provides, which has have highlighted Article 5(1)(e), that if the award has been annulled or part of it has been annulled by the seat, then the court may refuse recognition or enforcement. And this issue equally came up in the Great Lakes case, where Justice Mobiru also pointed out that this can be a ground for refusal. So the issue of committee is to ensure that there is uniformity, consistency, and predicability of some of these principles. We don't want to have people running around with awards and trying to see which country is able to enforce my award without following due process. So that's where it has to tie in, one, into the New York Convention, but secondly, it would have to look at good relations. You do not want to enforce when the seat has already made or has annulled part of the award or has annulled the entire award. So that is what I would point out in regards to that case of ESO and what Justice Mobiru pointed out in the Great Lakes case, which is a recent decision and has been shared with the participants. Thank you.
Thank you very much, Albert. You've touched on the issues around committee and interstate arbitration options. And Robert, next is for you to help us appreciate and probably shed more light on the concept of sovereign immunity and statutory limitations when we come to enforcement of arbitral awards. We've talked about public policy. Albert has taken us through committee. So help us appreciate the nuances around international arbitral awards when it comes to state involvement, where are the limitations, and all that stuff around it. Thank you very much, Robert.
So there is a very interesting jurisprudence that has emerged around the question of to what extent can sovereign immunity play out in arbitration. Now, depending on, I touched on this earlier when I was talking about Aya. In Aya, Justice Mobiru says there are matters that are the preserve of the state, and those are not arbitrable. There, essentially, it goes down to jurisdiction, where a country has specifically excluded certain elements or certain questions, and those could be questions that relate to the function.
Some examples.
That's okay. So those could
some
include
examples for purposes of audience. The Ugandan.
So this is Justice Mobiru in Zabo uses the words, not in Aya uses the words functions of an organ of the state. I'll give you two examples. The first is where a statute says the question is not arbitrable. And that takes us back to the example I gave. You remember when we had the oil cases between Tallow Oil and Heritage and whatnot. The simple history, as I remember it from memory, is that URA assesses a tax on a transaction between Tullow and Heritage. Heritage is on its way out of the country, so URA designates Tullow Oil as a third-party agent for tax purposes. They go after Tullow, Tullow pays the tax, Tullow goes after Heritage for indemnity. Heritage says, no, 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 let's go to arbitration. The dispute goes to London, and Uganda says, wait a minute, you cannot arbitrate over tax questions. The tax question in the production sharing agreement was reserved for the Ugandan courts. The dispute comes back to the Tax Appeals Tribunal and then from there to the Court of Appeal. And I believe it is still pending in the Supreme Court all these years later. Or the Supreme Court has sent it back to the High Court for trial. That's a clear example where if the question had been about consideration away from tax, that dispute would have gone to arbitration. And indeed, certain other questions out of that controversy did go to arbitration, and Tullow did win in London and get judgments and awards and so on. The tax question, because the collection of taxes is a function of the Uganda Revenue Authority, that question is reserved as a sovereign question to be dealt with in the Ugandan context. If you have a contract that says, take the example of the Bujagali contract. The Bujagali contract, a crucial question in that Bujagali contract is the tariff. The tariff, when we as consumers of electricity like to think of the tariff as a number, that tariff is in fact a formula that gets adjusted depending on who does what. Now, if the tariff comes into question, the question is going to be, do you take that to the Electricity Distribution Tribunal? Because under the Electricity Act, you have a specific framework. You have a tribunal that deals with issues on electricity. Or do you take that before an arbitrator? Also remember that the Electricity Regulatory Authority that approves the tariff is a government agency. So you may have situations where either a contract or a statute specifically carves out a question for arbitration. I'll give you another example that involved Uganda, Kenya, and Tanzania. There is a dispute known as Blue Line versus EADB. In Blue Line v. EADB, a Tanzanian gentleman comes to EADB, borrows $2 million, I believe it was, or $1.5 million to buy trucks, to do haulage. They put his company in receivership when the trucks reach Mombasa. And then he goes and says, wait a minute, you knew I was borrowing to buy trucks to do haulage. My trucks are just coming. Why are you putting me in receivership? He takes that dispute to arbitration before a single arbitrator. For whatever reason, the arbitrator makes a finding awarding $61 million against EADB. What this gentleman's lawyer, a professor in Tanzania called Mgongo Fimbo, does is to go and take out garnishee proceedings against EADB. EADB then comes try and set aside the award. When they try to set aside the award...
But sorry for the interruption. Please repeat the parties. Somebody in the questions really wants to take note of the parties in this case. Kindly repeat the parties. Thank you.
Blue Line versus East African Development Bank. What then happens is that Mgongo Fimbo argues and says, no, arbitration, the award is final. You cannot appeal it. You cannot set it aside. There was no fraud. While they are still debating that, the arbitrator dies. Eventually, the question goes to the Court of Appeal in Tanzania that finds a way to set it aside. As a result of that dispute, the EADB treaty gets amended, the treaty for the establishment of the East African Development Bank. Now the treaty specifically says EADB can take you to arbitration, can take you to court. You cannot sue EADB. That's immunity. So where you have a specific instrument, I think I saw a message of someone asking about sovereign immunity. Investment disputes. Where you have a specific investment treaty, where you have a specific charter establishing an institution, the World Bank, the IMF, and so on, where you have an embassy in a country, where you have a specific act of parliament saying this question is not arbitrable, then immunity attaches. You will discover, however, that that is also why you then have Section 45 of the Arbitration and Conciliation Act, because ICSID was established to facilitate the settlement of disputes between host governments and investors. The argument being that investors felt in the 80s when ICSID was set up, investors felt that you would never have an even scale. Remember that in the 70s, you have the nationalization spate through Latin America, where you have American companies investing in oil and whatnot in Chile, and then the country is nationalized. So in the 80s, investors are saying, we can't take our money to a country like Uganda, and then the government just comes and takes over my mine or my oil field by nationalization. Also remember that in our local context, you had Idi Amin, who came and just basically, people forget that Idi Amin compensated the Indians. That's a story for another day. But he basically came and nationalized expropriated property. In those sorts of situations, that's the background towards the establishment of ICSID, countries saying we need to have a way to go after investors. So for the person who asked about investment disputes, there's really 3 points there. Number one, is there a bilateral investment treaty? Number two, does the treaty provide for what is arbitrable? You will find, for instance, if you look at the BIT between Uganda and South Africa, that BIT is limited in scope. What is the scope of that treaty if it exists? Number three, what kind of mechanism does it provide for? If this is an ICSID country, you will probably find that it says in the event of a dispute between Uganda and South African investors, or Uganda and Turkish investors, we will refer the disputes to ICSID. So that's how some of those disputes come up. But the key question is, the question of law that you're dealing with, is it one that is contractual, or is it one where the law has specifically put a limitation on what can or cannot be arbitrated? If an act of parliament says this question will be tried by the Tax Appeals Tribunal, it has exclusive jurisdiction, you go to tax. If the Act has said, Electricity Act has said you go to the Electricity Tribunal, you go to that tribunal. You do not go to arbitration.
Thank you very much, Robert, for that in-depth explanation.
Just to add,
yes, please, go ahead.
In terms of sovereignty, I think in 2023, the Attorney General presented an amendment to the Public Finance Management Act, specifically a statutory instrument for protected assets, which you cannot attach, specifically Schedule 4. And it provides assets owned by diplomatic mission of the Republic of Uganda, property owned by the military, cultural heritage, public utility, including aircrafts, components of aircraft owned by a carrier, the national carrier in Uganda, being Uganda Airlines, and all these assets. Now they are in the category of protected assets. So in line with the case of Blue Line, EADB, and all the other submissions he has made, equally in Uganda, we have that protection or sovereign immunity that places certain assets away from attachment by a successful party who wants to enforce maybe against the state in the case of an investment treaty arbitration or a commercial arbitration by way of a foreign award.
Thank you very much. Thank you very much, Albert. Thank you very much, Robert. Thank you very much, David, for this insightful discussion on enforcement of foreign arbitral awards. Our time is fast catching up with us, and we will have 1-2 more questions for the panelists before we start getting into the admin issues and going to a Q&A. And to pick up from where Robert ably discussed how things can change in the course of an arbitration proceeding, whether as a sole arbitrator or a legal statute or a national policy. I would like to talk about interim relief. I'll give the panelists each a minute. You can choose a case of your liking and give us what you see is the usefulness, if at all, of interim relief or interim measures or partial awards in enforcement of foreign arbitral awards. We'll start with you, David.
Thank you, Mariam. The process of issuing interim or partial awards is very useful. We've seen it in Zabo. The latest Zabo decision is in regard to the final award. It's a mechanism where the parties can agree that the arbitrator first determines the question of liability. So if there is an issue of who of the parties breached the contract, you can ask the arbitrator to first determine that question, where the resultant award will be a declaration. So a declaration is an award. And then the next issue to be determined will be quantum. So if the arbitrator makes a finding that the respondent was responsible for the breach, he can then go ahead and make the decision on how much the respondent should compensate the claimant. It happened in Zabo. The arbitral tribunal first made findings on rights, and then they brought that to the courts for enforcement, and then subsequently the money element. Now, why is it necessary? It plays a very big role. The biggest role that I have seen is mainly in construction disputes. There is usually a window after, there's usually a window of 56 days between an adjudicator's decision and an arbitral award, most especially in field conditions of contract. Now, the window of those 56 days was created to enable the parties have amicable settlement. And this is a method to promote cooperation and ADR. So the parties can first agree that the arbitrator makes a decision on who is liable. Once that decision has been made, then the parties can have an opportunity to explore a settlement in light of the fact that they now know who is responsible. Many a time, once the parties have negotiated and come up with an amount that one party can compensate the other, it is reduced into a settlement award, into a settlement agreement, which then is sent before the arbitrator, and then the arbitrator will enter the consent award. So it will save time to the extent that the arbitrator then doesn't have to go ahead and make a decision on the quantum. And secondly, it can even promote reconciliation. So it's a very useful method. That's all I can say. Over to you, Mario.
But your take on interim relief? Okay, Robert, please, while Albert comes on, what are your thoughts on partial awards and interim relief as far as enforcement is concerned?
So there are really two questions there, Mariam. Interim relief can arise in two scenarios. The first is before the award is rendered. That one, I believe, is the most straightforward one, where you want to preserve assets before the arbitration is concluded. Even if it's a foreign arbitration, you come to the High Court in Uganda and get an interim measure of protection under Section 6. The second one, which I think has been a little controversial and on which now we have two decisions in the High Court, one of them being a Zabo decision, another being a Vantage and Simba decision, is what happens post-award, but before enforcement. That's post-crucifixion, before ascension phase. Or for those who subscribe to the Catholic faith, that purgatory phase. Between the time the arbitrator renders an award and the time that the award is recognized and enforced. The position of the law as I understand it now is that what happens is you have the right to apply for interim measures pending enforcement. Now, why is the question a controversial one? Because ideally the arbitral award concludes the arbitration proceedings. Once the arbitrator renders the award, the arbitrator is functus official. What the High Court has said is there will be no wrong, no party shall suffer a wrong to be without a remedy. The High Court cannot stand idly by and watch an award going to waste because of the conduct of one of the parties. In one decision, Justice Mubiru says, the High Court in those circumstances retains a limited jurisdiction to give pre-enforcement but post-award measures of protection solely for the purpose of preserving the award. Otherwise, the award would be worthless if the assets are dissipated. In the other case, Justice Ochaya has said the court can invoke its inherent powers to give interim measures, and he did grant those measures.
So thank you very much, Robert. If I hear you well, you seem to say interim measures to some degree can work as the vaccine against the award falling apart in its entirety when it's passed. So it kind of aids enforceability. Thank you very much.
Yeah,
Time is not. So we are going to open up this discussion to the participants in a Q&A. And we'll do it in such a manner that if you have something to say, you raise your hand and then you'll be let in to ask your question. You can ask generally or direct it to one of the panelists or type in the chat room and then we'll address it. So while we wait for participants to ask questions, we'll go to the chat room and look out for the questions that have been posted in the course of this webinar. The first one being, are there any grounds for refusal of recognition and enforcement of a foreign award under relevant international conventions or domestic laws? Are there any grounds for refusal? I think these were touched on, but Albert, quickly, would you give us the 1, 2, 3 of grounds for refusal of enforcement? We seem to have lost Albert. David, do you want to take us through that very quickly? We touched on it, but oh, great. Albert is back. Thank you. 1, 2, 3.
Like I mentioned, the grounds for refusal under Article 5 of the New York Convention are similar to what is provided for under Section 34. But as I mentioned, the courts have said the effect is different. Under 34, you want the award to be set aside. Under Article 5, you want recognition and subsequently enforcement. Now, the first ground is incapacity or invalidity of the arbitration agreement, which is similar as what is provided for under Section 34. The other ground is the notice of appointment of the arbitrator, or there was lack of due process. And some of these were touched on in the IR case. I think there were several grounds that were raised by the claimant or the applicant why the award should not be recognized, and one of them was lack of due process. And jurisdictional issues also fall under this category. And then we have the composition of the tribunal. The procedure was not in accordance with the agreement or relevant law. So this where you disregard the provisions of the arbitration agreement and you appoint an arbitrator contrary to that agreement, unless you have had a variation deed or an amendment to the arbitration clause, then you have to stick to that. Then the fifth ground would be where the award has been set aside or suspended, which I hinted on when I was talking about the ESO exploration case and partly what was in the Great Lakes case. If it has been set aside at the seat, then in enforcement, you will not, or the court dealing with recognition and enforcement will not do so because it has already been set aside at the seat of arbitration. And then there are several. I hope our participants will have an opportunity of looking at the New York Convention in itself, because when you look at our act, it does not go to the grounds for a refusal. It does not provide for the same. So it is important that our participants also look at the New York Convention. Maybe Bridget will share a copy of the convention so that they're able to appreciate those grounds as provided for under Article 5. Thank you.
Thank you very much, Albert. The next question is to David. David, you mentioned a matter that was dismissed on grounds that the jurisdiction of the subject matter was a preserve of the Electricity Disputes Tribunal. Kindly pardon the parties on the case. I think they want you to tell us who the parties were so that they can read further on it. David?
Thank you, Mariam. It wasn't actually a dismissal. It was an application for recognition and enforcement of a partial award in respect of Great Lakes and Zabo. So Great Lakes and Zabo has various decisions from Justice Mugiru. One of them was recognition and enforcement of partial awards. There, the judge partially enforced the declaration and declined to enforce the aspect which was a preserve of the Electricity Disputes Tribunal. So he did not set aside the award.
He did not dismiss per se.
He didn't. He only severed. So he left a certain part which is enforceable and enforced it. Then the other part he declined to enforce it. Thank you.
Thank you. As Robert clearly explained, that with arbitration, you have to be like a good chef. You pick out the parts that you can use and the ones that are not in your purview, you put aside for where they are best suited to be resolved. The next question is to you, Robert. Somebody wants more light to be thrown on the issue of investment disputes. I think enforceability and recognition of investment disputes. Robert?
When I first saw it, investment disputes will depend on, I would conduct a three-part analysis. The first analysis is the contract in front of me. What does the contract actually say? Does the contract refer to arbitration? And if the contract refers to arbitration, is the subject matter arbitrable? Now, Albert did explain the part that I had missed out, for which I am grateful. Once I determine it's arbitrable, I go to the second element. Investment disputes, usually you're also talking about the context of bilateral investment treaties. Am I an investor in a country that has a bilateral investment treaty with Uganda? What does that investment treaty say? Does it say I can refer the dispute to arbitration? Does it say where? Is that treaty consistent with my agreement that I have? When I am done with that analysis, I go to the third step, which is, okay, if the treaty does say, if the investment treaty does cover my dispute, do I then trigger according to the investment treaty? The short answer is yes. And that's where I go into the explanation on ICSID and the history of ICSID and where it comes from. If you find that, and there's another, maybe to add, there will be the question of convenience, which is you want to go to ICSID, but please remember you will have to fly to Washington, DC. Maybe now post-COVID things may have changed, but that is where things will lead you. And it also will depend on who you're fighting with. Are you fighting with the state? Are you fighting with an agency of the state? Because those two are different. Arbitrating against the Attorney General is different from arbitrating against UETCF or arbitrating against UNRWA, which may be a parastatal. Does it have jurisdiction to arbitrate? Does it have jurisdiction to enter into this contract? And therefore handle the dispute the way that it has been. So the question on investment disputes, I think, is a very subjective one. A colleague called me yesterday to consult about a dispute involving, I believe it's a ministry, but the dispute is, I think, going to the ICC. what's the scope of investment disputes that you have in mind? Is there a treaty? What does your clause say? Remember, in arbitration, really the supreme position you're starting with is what did the parties agree to in their arbitration clause or in the arbitration agreement. That is where the party autonomy is, and that is where most jurisdictions will say, what did the parties agree to? The courts are going to enforce that agreement. Thank you, Maria.
Thank you very much. Thank you very much. Thank you very much, Robert. Is the webinar being recorded? Will it be shared? Yes, the webinar is being recorded and it will be shared in due course. Kindly share the CIAB calendar for activities. It will be shared shortly. Thanks for the very educative session. It is as if we have a full course. Thank you very much, Philip, for saying that. And we hope to stay in touch for more such insightful conversations. The other question, Albert, is it procedural to apply for stay of proceedings for enforcement of an arbitral award? Albert?
Of course, to answer that question, because the question is the stay pending what? Like pointed out, at the point of recognition and enforcement, you're looking at, you need the court to recognize the award and then subsequently enforcement. Now, the issue of stay would not arise because one, the concept of finality as pointed out by Robert and David, the issue, if the court has already recognized the award, when it comes to enforcement, there's nothing else left to do but to enforce. Since you cannot appeal, you cannot set aside because it has been recognized. So stay, especially in regards to foreign awards, after recognition is not something that is possible. Hello?
Thank you very much, Albert. Yes, please. Was somebody's mic unmuted? Okay, the next question. This is to Robert. In the event that an award has been set aside by a court under Section 34 of the Arbitration and Conciliation Act, what could be the next step for the parties? Do they appoint new arbitrators? I mean, are they sent back for arbitration since the parties must resolve the dispute by arbitration? So in event that an award has been set aside, Robert, somebody's asking that one directly to you.
I will ask my colleagues to guide me here if I am wrong, but my understanding is it depends on two things. One, why was the award set aside? If it was set aside on grounds of public policy, then it is quite possible that even if you go and get a fresh award, you will still have the same public policy issue. On the other hand, if it was set aside for misconduct of the arbitrator, then I believe that your remedy in that case is to restart the process. There's a caveat. The caveat is, are you still in time? Because the 6 years of limitation don't stop running just because your arbitration hit headwinds. Arbitration does not stop the time from running. So if you spend 3-4 years in arbitration, then you spend another 3-4 years fighting applications, and then along the way your award gets set aside and you can't commence afresh, then I think you're out of luck. That's the way I understand it. But I am curious what Albert and David think.
Albert, David, you have something to add to that, please?
Mariam, the question again?
The question is in the chat room in reference to if an award has been set aside under the Arbitration and Conciliation Act of Uganda, I believe. What are the remedies for the party? Do they appoint, basically, do they restart the process?
Thank you, Mariam. depends. There was a security fund. It was nullified by the Supreme Court. And the reason for nullification was basically that there wasn't a valid arbitration clause in light of the fact that Alcon Kenya, which won the award, assigned the contract to Alcon Uganda without the consent of NSSF. Therefore, due to the principle of privity of contract, Alcon Uganda could not commence arbitral proceedings. So it was set aside for want of an arbitration clause. So ultimately, the net effect was that the matter was referred back to the High Court for trial. So that's the first consequence. If an arbitration clause is nullified, then there's nothing to arbitrate anymore. So you go through litigation. If it is set aside for other reasons, other than invalidity of arbitration clause, or maybe one party wasn't accorded a fair hearing, or maybe certain aspects were not arbitrable, you have to reconstitute the tribunal, or you go back to the same tribunal and hear the case. In certain circumstances where an award has been partially set aside, for example, in the case of, it involved Rocco Construction, the case involving the Steel Hotel. It was a decision of Justice Mobiru. In that case, the award was partially set aside. There was an award for general damages over and above an award for liquidated damages. So the award for general damages was set aside, and the judge referred that aspect back to the arbitrator, basically to engage in an exercise of like rubber stamping, to sever away that part of general damages and then reissue the award without it. So those are the three circumstances. Over to you, Mario.
Thank you very much, David. Before you leave the floor, being the construction expert we have on this panel today, there's another question that directly gets into that. And the participants would like to know that for the most part, construction contracts are based on the PPDA contract. That's usually the only reference to using Arbitration Act but it's never detailed. But it's never a detailed arbitration agreement. In this case, that is in the case of construction contracts based on the PPDA Act. Does that mean that that's arbitrable? The question is not very clear, but I think if you could just throw more light on the PPDA-based contracts and arbitration, I think therein we'll find our response to this question. David?
Yes, today's topic basically is enforcement of arbitral awards. So I want to spend a lot of energy on that. We can have a webinar on that, but in brief, the Government of Uganda standard contract, which we commonly call the PPDA standard contract, has an arbitration clause. That arbitration clause is not that detailed, unlike other contracts. It's not the only construction contract that is used in Uganda. Uganda also use the field conditions of contract, which are detailed. But what I can tell you is that the PPDA one, or the Government of Uganda one, has a valid arbitration clause. It simply says that if you're dissatisfied with the decision of the adjudicator, either party will refer that dispute to an arbitrator whose decision will be final, and the arbitration will be conducted in accordance with the Arbitration and Conciliation Act of Uganda. Now, the Arbitration and Conciliation Act of Uganda is detailed on how to handle the arbitration. So there was no requirement necessarily to have an arbitration clause which covers half a page. If you have an arbitration clause which says the arbitration will be conducted in accordance with, say, the LCIA rules, or the SIAB rules, or the Arbitration and Conciliation Act of Uganda, in a way, it has prescribed the method that will be used to resolve that dispute. That's how far I can go, Maria.
Thank you very much. Unfortunately, time has really caught up with us. Looks like this is a very insightful webinar where we could have used a lot more detail and a lot more time. but not to be discouraged. One, our activity calendar has been shared. Before you leave, please take a look at it. We will have more webinars. And we look forward to having you on some of them or all of them. And we thank you so much for being part of this afternoon where we have learned about enforcement of arbitral awards. We thank the panelists, we thank the participants, we thank the admin, we thank the CIAB members, and we hope to see you in the next ones. But before I go, I would like the panelists to give us 30 seconds of their parting shots on this subject matter. And we look forward to having you again. We'll share our contacts and then we'll hope to hear from you in the coming days. Start with Albert, please, your parting shots on the subject matter for today's webinar.
Yeah, I thank everyone who has managed to attend today. Of course, enforcement, Uganda is becoming a pro-arbitration country, whereas we're among the first African country, one of the first African countries to embrace arbitration. It's only in the recent years that activity in arbitration has quite geared up, and as you see, most of the decisions on enforcement of foreign awards in the recent past, it means we have a lot of work to do and make the law much clearer and make sure that we benefit from arbitration or ADR as a whole. Thank you.
Thank you very much, Albert. Robert, your parting shots.
Thank you very much to you, Mariam, for leading us through what I think has been a really stimulating and intellectually enriching discussion. And many thanks to CIAB for putting together the webinar and for considering me worthy of participation. I'm grateful to all our participants who've taken a Friday afternoon to spend it with us, and for the interest. The questions display a really keen interest in the arbitration process. And I personally have found that, and my parting shot to anyone interested in the space but who hasn't taken any formal training in arbitration, I would say, please sign up for CIAB trainings when they come. Many of us litigate and assume that just because we can litigate, that makes us good arbitrators or arbitrators. And the two things are really quite different. The two worlds are really quite different. The rules are different. It is not rocket science. It is so much fun, but it is a different ballgame. And I think that in the end, when we all focus on resolving disputes, we as lawyers will be better for it. Thank you very much, and I wish you all a wonderful weekend.
Thank you, Robert. Thank you so much for coming in. Before you go, last but not least, David, and to our audience, I just want to say this, save this for the last. David is also the chairperson of the Chartered Institute of Arbitrators, the Ugandan chapter. So I will speak as a panelist, but also in his capacity as the chairperson of this chapter. David, over to you.
Thank you, Mariam. You've done a tremendous job in moderating this webinar. I've enjoyed it very much. I've enjoyed interacting with all of you. My parting shot is one. There's a certain aspect that we often ignore, but which is very fundamental, and that is the word waiver. There is a section 4 under the Arbitration and Concession Act, which says that where a party looks on when certain procedures are not being followed during the arbitration process and does not raise a finger or complain, they will not be allowed at a later stage from raising that issue. The reason why I'm emphasizing it in respect to this webinar is that if you're aware of a certain aspect that may be contrary to public policy and you do not raise it before the arbitral tribunal, or if there is a matter which is not arbitrable but it's intertwined with other matters which are arbitrable, and you don't raise it at the first opportunity or during the arbitral process, there are situations where you will not be allowed to raise it, to refuse enforcement. It happened in the Aya case, where they raised issues that people are not given a right to be heard. The judge said, you waived by your failure to participate. That's my parting shot, and also to thank you very much and to tune in to all our webinars. and welcome you to Nairobi, Kenya, where we shall be celebrating 40 years of SIAB Kenya, our mother branch. It's between the 15th and the 17th of May. Have a blessed weekend. Over to you, Mario.
Thank you very much, participants, for coming up and spending time with us on a Friday afternoon. Thank you very much, panelists. Thank you very much, the entire SIAB team behind the scenes to make this webinar possible. From us to you, have a great Friday and hope to see you in the next webinar. Please check out our calendar and have a great weekend.